Justices and Heever.
Defendant Heever and Conradie families, Chief Justice and Deputy Chief Justice and former DCJ Zondo who are joining us on the virtual platform, DJP Goliath, former President of the Supreme Court of Appeal, retired Justice Howie, stakeholders from various parts of the province and the country, staff members of the OCJ, ladies and gentlemen, good morning. I would like to extend a warm welcome to our esteemed Defendant Heever and Conradie families who are here today. From the Defendant Heever family, we have Dr. F.A. Nietling, Andre, Margaret, Francois, and Natalie Retief, and Kathy, Christo, and Duncan Porchita. From the Conradie family, we have Mrs. Conradie, Alex, Anya, Emma, Christian, Lisa, and Jill Maxwell. Welcome. Today, we gather to honor our departed colleagues, Justice Leonora van den Heever, who passed away on 20 November 2025, and Justice Johannes Hendrik Conradie, who passed away on 24 November 2025. As is customary, we hold memorial sittings for judges who served on our bench even after their elevation to the senior courts, and we want to keep to that tradition. The judges we honor today not only left a legacy from which we benefit and are proud, but they also made significant contributions to shaping our law and cementing their places in this country's history books. We are going to hear a lot about that today. First, we have Justices Howie and Brand, who also hail from this division and who know our departed colleagues better than we do. Justice Howie will deliver the eulogy of the late Justice van den Heever, followed by Justice Brand, who will give the eulogy in respect of Justice Conradie. Justice Howie.
Thank you, Judge President. We gather to honor the life and career of a remarkable woman. It is almost 100 years since Leonora van den Heever was born in Windhoek. She was South Africa's first woman judge and South Africa's only woman judge for 24 years. Her record is one of exceptional achievement and service. As Mrs. Christo Nietling, she served family and community. As judge, she served the law and the nation. By family, friends, and colleagues, she was referred to as Leo, and I shall follow suit. Leo's father was a prize-winning Afrikaans poet and prominent judge, his legal career culminating as a judge of the appellate division. It was no real surprise that his writing and legal talents were instilled in her. She matriculated in 1942 at Oranje Girls' School in Bloemfontein, where she was deputy head girl, and proceeded to Pretoria University. She enrolled for a BA degree, majoring in English and Latin, and achieved that degree cum laude in 1945. She then studied for a master's degree in English. Contemporaneously, she tutored in English at a teacher's training college and lectured in English to first-year students at the university. She was awarded her MA cum laude early in 1948. She returned to Bloemfontein, where her father was then a judge in the provincial division, and after half a year of more English teaching, she became his clerk. Not much later, he was appointed to the appellate division, and she clerked for another judge, remaining a judge's clerk in the provincial division for the next 3 years. It was in those years that she decided to qualify in law. She enrolled as an extramural LLB student at the University of the Orange Free State and achieved the award of that degree at the end of 1951. In the interim, she had turned her hand to writing articles for local newspapers concerning interesting events in the trial courts. In 1952, Leo was admitted as an advocate by order of the Orange Free State Provincial Division and began practice at the Bloemfontein Bar. She kept the financial pot on the boil by writing short stories under a pen name published in the magazine Sari. She also wrote 2 children's books in her own name, one of which contained illustrations she'd done herself. In time, authorship faded as her practice grew. In June 1958, Leo married Christo Neetling. He was then employed in Bloemfontein, but not much later, he was transferred to Welkom, and the couple had to move. Leo had no office there from which to continue practicing, but the Bar Council granted her leave to practice from home, which she did till 1964 when they returned to Bloemfontein. The Welkom years, appropriately, saw the arrival of 3 daughters, born respectively in 1959, Margaret, 1960, Catherine, and 1962, Francisca. Leo's practice developed successfully to the extent that she was able to apply for Silk, which was awarded to her in 1968. Then in 1969, after a short spell as an acting judge, she received the permanent appointment, which made her the country's first female judge. The court to which she was appointed was the Northern Cape Provincial Division in Kimberley. She officiated in that court for 10 years. Early in the Kimberley decade, she was awarded the Orange Free State University's Chancellor's Medal, a decoration acknowledging excellence in legal achievement. In 1973, the Kimberley Museum celebrated, with appropriate display, which still stands, the country's various firsts that were linked to Kimberley: the discovery of diamonds, street lighting, the first railway north, and Leo's judicial appointment. Extramurally, she served on a school council and the board of the William Humphreys Art Gallery. In 1975, called the Year of the Woman, Leo was invited to various South African and neighboring cities to speak about women's rights. Was sent by the national government to attend a conference on the subject in Washington and was honored by the Kimberley Union of Jewish Women as their Woman of the Year. In 1979, Leo was transferred to the Cape Provincial Division. She was on the bench of this court for the next 12 years. Members of the Cape Judiciary were then, as a matter of course, offered honorary membership of the next door city and civil service club. However, its constitution did not extend membership to women. Leo's arrival forced abolition of that restriction, attracting an article in a local newspaper headed Eerste Vrou in die Ramkamp. As had become typical of Leo's full-blooded approach to life and work, she on several occasions between court terms here acted in the Paputetswana Appeal Court. She made time for involvement in a variety of extra-legal interests and obligations. Trustee of the Cape Ballet Benevolent Fund, council member of the South African Youth Orchestra, chairperson of a government commission of inquiry into irregularities in the Department of Education and Training, and on the council of the South African Library. In 1987, she was honored by the Vroue Bureau as the Western Cape's Woman of the Year. In the second half of 1991, she was appointed an acting judge of the Appellate Division, and in the following year, she achieved another first on receipt of a permanent appointment as Judge of Appeal. In 1996, she was on leave in the first half of the year, but nonetheless accepted appointment as an acting appeal judge in Lesotho. In the second half of that year, she retired, but continued in judicial service by way of this court and a number of years in the appeal courts of Lesotho and then Swaziland. For 10 years after retirement, Leo chaired the Sunlight Demutualization Committee and thereafter confined her activities to family and some limited travel. Leo's record of service, commitment and achievement was justifiably recognized. She received Pretoria University's Chancellor's Medal in 1996, and the degree LLD honoris causa was awarded to her by Stellenbosch University in 1997. In 1998, the Pretoria University Alumni Council conferred on her the status of laureata for exceptional achievement and advancement in the interests of the university. In the same year, she received her second LLD honoris causa, this time from the University of Port Elizabeth. Leo's own account of her exceptional career she described in simple terms. My siening was dat ek geseën was met 'n besonder interessante en bevredigende dubbeldoor lewe as beide gesinsmens, gade van 'n baie besondere wederhelft en beroepsvrou wat haar werk terdee geniet het. If I may translate, my view was that I was blessed with a particularly interesting and satisfying double life as both family person, wife of a most exceptional other half, and a professional woman who enjoyed her work exceptionally thoroughly. It was no doubt so that Leo enjoyed her work, and she was conspicuously able in its performance. As judge, she was fully prepared for a hearing and quick to steer argument to the point if counsel tended to stray. This would be done calmly but firmly. Her judgments exhibited an admirable clarity of thought and expression. She contributed a conspicuous ability, energy, and intellectual thrust to the adjudication of the cases assigned to her. And as her record shows, she gave substantial time and attention to the performing arts and community issues. Both in and out of court, she displayed compassion and humanity. Leo was a friendly and generous hostess. Those of us on our own at appeal court sessions would from time to time receive a laconic invitation to a meal, clearly indicating her concern at possible loss of work time. Come to supper. You don't have to stay afterwards. Just grab, gobble and go. It could well be said that of all Leo's many achievements, perhaps the one that impressed the greatest number of people, both in and outside the law, was her undoubted success in making her way as a judge in a completely male sphere. She more than held her own, and her progress and promotions were fully merited. With us this morning, we have Leo's eldest daughter, Margaret Latif, and her husband, Andre, their son, Francois, and his wife, Natalie, and Leo's youngest daughter, Francisca, who has flown from the United States for today. We welcome your presence, and we share your admiration and respect for an exceptional life, caringly lived.
Thank you, Justice Brown.
Thank you, Madam Judge President. We are gathered to pay tribute to our late brother Judge, Johannes Hendrik Conradie. We are privileged to have with us his wife Catherine and 3 of his 4 children, Alex, Lisa and Christian. On behalf of the members of this bench, both past and present, please accept our condolences and our assurance that we share your loss. In April 2026 edition of The Advocate, Trevor Emsley, SC of this bar, wrote a tribute to Johan, in which he said that since he has not seen Johan for a number of years, he was rather surprised at the extent of the loss he experienced on learning that their paths will never again cross. I shared that experience, but on reflection, that deep sense of loss should not come as a surprise. I met Johan in about 1983 when I was briefed as his junior in Johannesburg in a defamation case which we lost against Sir Sidney Kentridge. I got to know him better when he took an appointment as a judge in the Cape in 1987. His children and mine went to Grooteskieu Primary School, where we both served on the governing body for a number of years. Until I took an appointment in 1992, I appeared before Johan quite regularly. Although by then we became friends, he was not an easy man to appear before. Unlike some judges I know, he never became irritated or unpleasant. He sat there with an amused, enigmatic smile, You never had no idea what he was thinking until he buffed you. Between 1992 and 2001, when I left for Bloemfontein, we served together on this bench, and from 2002, when he joined us in the SCA until his retirement in 2007, we served together in the SCA. During all these years, I got to know Johan well. Hence, I can say from experience that he was an exceptional judge, a great gentleman, and a wonderful colleague and good friend, with a great sense of humor, often at his own expense. Johannes Hendrik Conradie was born in Johannesburg on 15 June 1938, and he passed away at the age of 87 in consequence of injuries he sustained in a motor accident on 24 November 2025. He attended Laerskool Jan Sillier and Hoërskool Help Mekaar, both in Johannesburg, where after he spent a year at the University of Basel in Switzerland, which accounts for the fact that he could read both French and German fluently. He then went to the University of the Witwatersrand, where he graduated with a BA LLB cum laude in 1963. He joined the Johannesburg Bar in 1964, where he became a member of the famous group, the 621. He then took SOC in 1982, did his first stint as an acting judge in the then WLD in 1984. He was appointed to the Cape Bench in 1987 when he became a Cape Townian, because in his words, a Gautenger is someone who cannot find a job in Cape Town. In June 2002, he was elevated to the Supreme Court of Appeal, where he retired in 2007. Thereafter, he started a third career as a very popular, busy commercial arbitrator, from which he retired at the youthful age of 78. Johan's grandfather, also Johannes Hendrik, was the administrator of the then Cape Province, and his grandmother was a social worker, after whom the Conradie Hospital in Pinelands was named. His father, also a lawyer, studied at the University of Oxford, and then ended up as the CEO of the South African Airways. His mother, Renee, studied at RADA and became an actress. She then taught speech and drama for many years while still performing in radio plays. Johannes' family was very important to him. He was also very proud of them, and with respect, rightly so. His wife, Catherine, was a professor of law at the University of Western Cape. His son, Alex, holds a doctorate of chemical engineering and is a professor at the University College London. His second son, Ewan, also holds a doctorate in engineering, in his case electronic, and is a senior software engineer at a United Kingdom firm and teaches at the Open University. His daughter Lisa was a practicing attorney in South Africa before she moved to Australia, where she now practices law in the corporate field. His youngest son, Christian, is a full-time artist whose paintings, I'm afraid to say, very few of us can afford. He also has 7 grandchildren, ranging from between 2 to 26. If Johan did not become a lawyer, he would be well qualified for a whole host of other alternative careers. Perhaps because of his mother's involvement, he performed on the radio from about the age of 6. I understand that when he started, there was a special box in the studio for him to stand on in order to reach the microphone. While at Wits, he belonged to the drama club and particularly enjoyed acting in Shakespeare plays. He kept up with his radio performance well into adulthood and also writing radio plays, and later turned to dubbing television shows into Afrikaans. Most notably as the voice of the understudy Harry, the German investigator Derek, in a television series by the same name. One of Johan's great passions was his interest in history. While on the SCA, he took his colleagues to the battlefields in the Anglo-Boer War, like Magersfontein, Paardeberg, and Sannaspos, where he was able to give us a very learned and artistic rendition of what happened at the site. Johan's artistic and creative tendency also appears from his judgment. For instance, he started his judgment in Fourie versus Eerling in 2005 as follows: the audacity of its perpetrators and the credulity of the participants combined to produce a gargantuan fraud, notoriously known as the Creon Pyramid Scheme. So also is his famous comment on the interpretation of contracts in Lloyd's of London v. Skillia Properties in 2004, when he said that sophisticated semantic analysis is not the best way of arriving at the understanding of what the parties intended. Johan was a great storyteller. When I sat with him, he was always looking for the story behind the stories. Coming to your chamber, say, I'll tell you what happened in this case, completely off the record. In the same case of Skillia Property, he described the aeroplane involved as, and I quote, a Douglas D-3 aircraft popularly known as a Dakota. It later turned out that the Douglas DC-3 is probably not a Dakota, but Johan's description was far more interesting. If you look for another example of Johan's ability to make the law reports more interesting, you may have a look at the judgment in Unitas Hospital v. Van Wyk in 2006. I was deputed to write the main judgment. Edwin Cameron wrote the dissent. Johan agreed with me, but he obviously thought my cold black letter rendition of the facts rather boring. So he wrote his own judgment, with the consequence that if you were really interested to know what happened to the unfortunate Mr. Van Wyk in the Unitas Hospital, I recommend Johan's judgment. Johan's contribution in the law reports cover most fields, but I think his best known judgments were in the field of labor law and tax law. By way of example, he wrote the judgment in Western Platinum versus Commissioner of South African Revenues, a revenue which starts with a comment often quoted thereafter that the fiscus favors miners and farmers. As Trevor Emsley points out in his article, Johan was well known amongst tax lawyers, in jest perhaps, as a pro-fiscus. According to Trevor, he once slipped by slip of the tongue to the taxpayer as the accused. The reason he explained to me, I suppose also half in jest, is his thesis that if everybody pays their taxes, we can all pay a little less. This, I suppose, illustrates Johan's approach to the job of being a judge. He realized that being a judge is a great job. It is great because the only aim is to do the right thing. Unlike some other fields of endeavor, we are not motivated by any other agenda. But the fact that we do a great job doesn't mean that you are necessarily great. The fact that judges are human and sometimes get it wrong does not detract from the principle. Being a judge is also a very serious thing because it affects the life of others in so many serious ways. But the mere fact that we are involved in a serious profession does not mean you have to take yourself so seriously. Johan understood all that. Appreciating the seriousness of the consequences, he was always well prepared and always applied his exceptional intellectual ability to every case. But at the same time, he did not take himself seriously. He often saw the lighter side of things. In short, he was always fun to be around, particularly on the bench. I have noticed from Christian's paintings that he often used his father as a model. And what he succeeds in doing so well is to encapsulate that typical enigmatic smile that we all remember. The smile that indicates a sense of secret amusement. In a review of one of his paintings, an international art critic said the following of the painting, and I quote, "Reading a book," this is now the author, reading a book, "I came across the word ataraxia, which I needed to look up. It is defined as a state of serene calmness peace, freedom of fear, stoical indifference. And the review artist still continuing, I'm thinking about that word, and I'm thinking about Christian Conradie's painting of an elderly man, eyes closed, looks content. The review artist critic obviously did not know Johan, but the author obviously, but the painter obviously did, and described him in a way that we will always remember. Thank you, Madam Justice.
Thank you, Justice Point. The next speaker from the line of our speakers is Ms. J. Morongwa. Ms. J. Morongwa from SAC IWJ. Please take the platform.
It's an honor for the SAC IWJ to be invited to this wonderful moment. There's two giants, as well as the presence of the family who share those moments with them. Thank you. In continuing, most of us actually met these two giants through the law reports, the pages in the law reports, and it is wonderful to hear that they carried through the principles that led them and directed their path as they dispensed with justice. It is indeed notable that both of them, they served with and they led with excellence and integrity. I would take a moment to pause and make a special reference to Judge van der Heever, because coming from the Association of Women Judges, International Association of Women Judges, and as the South African chapter, we really stand on the shoulders of this giant. It is not a small feat to be a groundbreaker. Anyone who has been involved in that kind of calling would appreciate the tenacity it requires for one to persist and pursue the vision that they have carried in their hearts and leave such a legacy that will stand the test of time. Having said that, and coming back to Judge Conradie as well, the two of them, one can honestly say their career trajectory shows that they did not remain complacent. Colleagues, we have been warned that familiarity breeds contempt. So it is very important that we do not allow ourselves to be complacent, taking a leaf from these two giants, and to remember that we need to keep guard of that as we interact with one another, as we practice the law, as we approach our work, because South Africans and all those who find themselves within the borders of our country are looking at us to provide a robust and healthy legal justice system. Having said that, and being called to step forth and walk in the path of these giants, we all have our own individual journeys, but we remember always that just like anybody who is a runner or a walker, you need good-soled shoes or well-made shoes to carry one forth in this journey. So we are sure-footed because our souls have been cemented, or they have been provided an extra layer of comfort, because the principles that they have carried through, the legacy that they have given us, provides that sure footing for us. Indeed, as one takes a walk in their journey, you might decide to walk it or run it. If you sprint it, no judgment there. We hope that you'll make it through. So one is always called to remember and to ponder and reflect that with the well-soled shoes, the legal scrolls in our minds and in our hands, with the Nkosi Sikelela in our hearts, we push on, we progress, and we advance. Thank you very much.
Thank you, Ms. Morongwa from the SAC IWJ. Our next speaker is Ms. Jamie Curdy SC from the Cape Bar.
Judge President, judges, family of Judge Conradie and of Judge van den Heever and colleagues, thank you for this opportunity to speak. The Cape Bar extends its heartfelt condolences to the families as well as to their friends and former colleagues. Judge van den Heever indeed leaves a legacy which is, in the words of the Chief Justice, both enduring and transformational. In 1952, when Judge van den Heever joined the Bloemfontein Bar, a small bar at all times, but particularly then, she began her journey as a pioneer and example for women counsel and women jurists of the future. Given the conservative attitude that still prevails towards women in law in many sectors, it is difficult to imagine what Judge van den Heever faced from many of her male colleagues at the bar and many attorneys who no doubt had serious concerns about briefing a woman counsel to represent their clients. I also have no doubt that the Bloemfontein Bar Council gave the married Judge van den Heever permission to practice from her home in Welkom, in the belief that that would be the end of her career and they would probably never see her again. After all, and as one of her colleagues had said, for her, as a married woman, her practice must have been just a hobby. As he and his colleagues learnt, when you take a pot shot at Leo van den Heever, you merely fortify her resolve and belief in herself and in women in the profession. By that time, Judge van den Heever had built a strong practice. Her years in the trenches of the Magistrates' Court in Welkom served her well. Both there and in the High Court in Bloemfontein, she was known to be a formidable opponent, but pragmatic and reasonable and honest to a fault. Her application for silk was bold and brave, as was she. Silk was conferred on her in 1968, leading the Minister of Justice to, by his own admission, perform an experiment, appointing this new silk as an acting judge on the Bloemfontein High Court bench in 1969. This was followed, as we know, to a permanent appointment in 1969 to the Kimberley bench and a transfer in 1979 to the Western Cape bench, and in 1991, an appointment to what was then the Appellate Division. Those characteristics that made her an eminent counsel also made her an eminent judge. Formidable, but for the most part no longer one's opponent in court, pragmatic, fair, and again, honest to a fault. Her appointment, as we have heard, to the Western Cape caused the most consternation for the employees of the City and Civil Service Club. This being a men-only club, it had indeed boldly extended automatic honorary membership to judges' appointment. They were safe, knowing that these, of course, would always be men. Judge van den Heever was less concerned than they were. She accepted the membership, and the City and Civil Service Club, by virtue of her appointment, was no longer a boys' club. Her judgments reflect her love of writing, being also, as we have heard, an author of children's book and other literature, and a writer of articles under a pseudonym for Sari magazine, which continues to this day. Reference is made in tributes to Judge van den Heever regarding the leading role that she played when the Divorce Act 1979 was introduced. Certainly in Law 43 applications, her judgment in Micklem versus Micklem, 1987 decision of this division, is still relied upon. I hasten to add that we rely on the principles, quantum set out in her judgment, being at that time a contribution to legal costs of 27,500 Rand. If we got a contribution like that today, we would have known we'd lost. Judge van den Heever was also committed to the arts, and she served as a member or trustee on a number of boards. In his tribute to her, Justice Johan Kriegler wrote, "But one thing Leah was proud of and would want me to declare, in an era when women were disparaged, in a world where the legal profession was all but closed, she proved that a woman, an ordinary woman, who was prepared to put in the hard miles, was at least as good as a man. She would compete and not merely survive, but flourish and come out on top. We mourn the loss of not an ordinary woman, but an extraordinary woman, who I'm told had a keen sense of humor. And what option did she have? She worked almost exclusively with men. She has left an extraordinary legacy to not only women in the profession, but to all members of the profession." In respect of Judge Conradie, we've heard he completed his LLB cum laude in 1963. joined the Johannesburg Society of Advocates in 1964, and in 1982, silk was conferred upon him. In 1987, he was appointed as a permanent judge in this division and elevated to the Supreme Court of Appeal in 2002. Trevor Emsley, SC, in his tribute to Judge Conradie wrote, "South Africa benefited from the judicial wisdom of Judge Conradie for 20 years and 6 months, an illustrious innings by any standard. Judge Conradie was recognized for his exceptionally sharp mind, his sharp and fine turn of phrase, and indeed his sharp tongue. He enjoyed engaging with counsel in court, but did not suffer the unprepared counsel gladly. To say that one was nervous when appearing before Conradie J would be an understatement. He rather liked that reputation, saying in the passage of court to a colleague who is now a silk, but had only been at the bar for about 7 years at the time, 'I believe I am the judge who makes you the most nervous, Miss G.' To which she replied, 'Oh no, Judge, that spot is reserved for Judge Nell, but you do come a close second.' Judge Conradie approached his matters as a judge with the same precision and rigor that he approached his matters when counsel. He and Judge Binns Ward, an acting judge at the time and in 1987, made headlines when in an appeal before them, they found that the magistrate had been incorrect in his finding that the 6 petrol bombs found in the possession of the 3 accused were armaments as defined in Section 32 of the Arms and Ammunition Act. They were acquitted. While on the SCA bench, Judge Conradie contributed to many reported judgments, addressing matters regarding procedural fairness, tax liabilities, and contractual interpretations. When one was looking for a judgment to support one, a Conradie judgment was one that was good to have. Trevor Emsley takes the view that in respect of tax matters, Judge Conradie got them mostly correct. Judge Conradie's sense of humour in court and his enigmatic smile was noticed by counsel on many occasions. I think he found motion court somewhat unstimulating and found ways to entertain himself. In one divorce matter undefended, which I had in front of him, the child's name was Nikita. After leading evidence, Judge Conradie said to her, a fairly unsophisticated woman, "Your daughter's name, that is interesting. Are you perhaps a fan of the late president?" She looked at him, puzzled, and said, "No, of course not, Elton John." And he smiled. We mourn the loss of Judge Conradie. He will always be remembered by us at the Cape Bar, and I know the judges on the bench, for his exceptional contribution to law in South Africa. Thank you.
Well, thank you, Ms. McKellar. The next speaker is from the Law Society of South Africa, Mr. Emmett Thong.
Honorable Judge President Mabinga Bakwan, Deputy Judge President, esteemed bench, distinguished members of the legal fraternity, and most importantly, the family and loved ones of the late Justice van den Heever and the late Justice Conradie. I crave your indulgence to stand on the protocol previously established. Today, we gather to honor 2 giants of our jurisprudence, whose lives remain intrinsically bound to the history of the Western Cape High Court. We are gathered here to remember 2 distinguished figures of our legal fraternity, Justice van den Heever and Justice Conradie. Their contribution to South African law spanned eras of profound transformation, and their legacies compel us not only to celebrate their brilliance, but to reflect on the current state of our legal system. Justice van den Heever broke impenetrable barriers. Appointed as South Africa's first female judge in 1969, she ultimately served on the Supreme Court of Appeal. She was not simply a trailblazer for women in a fiercely patriarchal profession. She was a fierce defender of human dignity. Long before the advent of our constitutional democracy, Justice van den Heever used her position to challenge indignity of imprisonment for indigent civil debtors, advocating for fairness in a system that often favored the privileged. Justice Conradie, who created this very division before his elevation to the Supreme Court of Appeal, was celebrated for his rigorous intellect, sharp wit, and unshakable commitment to the rule of law. He embodied an independent legal philosophy that refused to tolerate executive overreach, famously asserting the right of individuals to be treated fairly by public authorities. His jurisprudence was marked by a deep respect for procedural justice, ensuring that legal remedies were always available to develop the trajectory of the South African legal system. Yet, to truly honor their memory, we must speak frankly about the controversial issues plaguing our legal fraternity today. We operate in a society grappling with immense poverty and inequality. As legal practitioners, we face a crisis of public confidence. The transformation of the legal profession remains painfully slow. For example, the legacy of unequal briefing patterns continue to shut capable women and Black legal practitioners out of high-value legal work. If we are to honor Justice van den Heever's lifelong for an inclusive profession, we must treat transformation not as a theoretical debate, but as an urgent obligation. Furthermore, the independence of our judiciary is sometimes tested by political pressures and resource constraints. Justice van den Heever and Conradie taught us that a judge's only loyalty is the Constitution and the law. It falls upon us, the Law Society of South Africa, and every practitioner present to fiercely protect this independence without fear or favor. What did these two justices stand for? They stood for a legal philosophy grounded in uncompromising integrity, discipline, and a deep empathic understanding of the human conditions. They understood that the law is not a mere academic exercise, but a vital instrument for achieving justice. Their contribution to our jurisprudence is indelible. They helped bridge the divide between a formalistic past and the transformative rights-based society we strive for today. Let us use the memories of Justices van den Heever and Conradie as our moral compass. Let us recommit to building a legal system that enjoys the confidence of all citizens, not just the rich and the powerful. May we emulate their courage and protect the justice system with the same unwavering commitment they showed throughout their illustrious career. Let us remember the dedication of these two legal giants. I leave you with the words of former Chief Justice Arthur Chassaset, who famously reminded us of our calling as legal practitioners. He said, I quote, "The judiciary can do little without the support of a strong legal profession, a profession which identifies itself with the needs and aspirations of all the people in South Africa, is likely to prosper. With much pleasure, let us protect our justice system." I thank you.
Thank you, Mr. Mutrong. The next speakers are from the National Prosecuting Authority, Ms. Henry Sidaki and Mr. Kilesa.
Honorable Judge President, the van den Heever family, members of the legal profession, distinguished guests, justices, thank you for the opportunity to say a few words in memory of the late Judge Leonora van den Heever. I am honored to represent the National Prosecuting Authority in acknowledging the varied and valuable contribution that Judge Leonora van den Heever made to the development of South Africa's legal and particularly the criminal justice system. Having been admitted to the bar in 1952, Leonora, or Leo as she preferred to be called, was one of only hardly a handful of women to practice as an advocate, taking silk in 1968 and ascending to the bench in 1969, where she was the only female judge for some 24 years, having been appointed to the Cape Bench in 1979. In 1990, I had the privilege of listening to her as the guest speaker at the Rustenburg Girls High School prize giving. And she was truly inspirational to us young women filled with dreams and a zest for life at the time. Leo van den Heever was a veritable trailblazer on so many levels. Reflections on her career point to her razor-sharp mind, her legal acumen, her skills as a writer, and a prolific contribution to the development of South African law. Her diversity of interests and commitment to serve was remarkable, particularly in the roles that she played towards the performing arts and music. She received various awards, including the Chancellor's Medal from the University of Pretoria, an honorary doctorate of law from the University of Stellenbosch, and the Women's Bureau Achievement Award. For her landmark achievements in the judiciary, the City of Cape Town conferred civic honors on Leo van den Heever on the 28th of April 2011. Yet charmingly and disarmingly, in 1959, she had written as follows: "That maar hy's mak, nee, sê oom Herklaas, maar toe hy oor die draad leun om die bokkie se ore te krap, vertrou die bokkie die vrede nie. Klein mensies is alles goed en wel, maar groot mense kan dalk gevaarlik wees." En hy spring weg en wip wip op sy fyn pootjies deur die kamp in. That's an extract from Wimpy in Wat Wou, written by Leo van den Heever in 1959. And if I may briefly translate, little people are good and well, but big people may be dangerous. After all, Leo was mother to 3 daughters and herself a daughter to Margaretha Max Rautenbach, a pilot and as such a pioneer in her own right. Judgments written by Judge van den Heever reflect that humanity and a deep understanding of the human subject which the judgment seeks to address. For instance, in a maintenance matter which served before her in the Cape High Court, Judge van den Heever writes of the mother's claim for more financial support because, and I quote, "Soos seuns van daardie ouderdom maar is, soos commando wurms deur die kosvoorraad woed." The contribution made by Judge van den Heever to the development of criminal law in South Africa was significant. In the matter of versus the state, she penned the unanimous judgment of the appellate division where the accused had raised a defense of amnesia, claiming a temporary lack of criminal capacity. Evidence of a number of forensic psychologists had been laid, and the judgment concluded the concept of automatism as a legal term, not a psychiatric term, in relation to persons who did not suffer from any pathology. The appeal against conviction and sentence was dismissed. Judge van den Heever also wrote the judgment of the appellate division confirming the conviction and sentence of Boy Ranta. The matter related to the largest clandestine methaqualone production syndicate, not only in South Africa, but in the world, as per the records of the United Nations at the time. It entailed the prosecution of the accused in relation to the production of 22 million Mandrax tablets with a street value of 230 million rand, which was at the time of arrest in February 1987. The conviction and sentence withstood the appeal. Judge van den Heever did not hesitate to express the court's displeasure at the abuse of police powers and spoke out against the hypocrisy of police officers who assumed different standards for themselves, distinct from those they impose on others. She noted that attempts by police officers to frustrate the laws were untenable and an aggravating factor. That was in the case of S versus Maritz. In a number of cases, she demonstrated the intricate balance which a court must strike in the imposition of sentence. Where an accused has previous convictions, albeit that they are fairly old, she found they reveal that, and I quote, "Despite having reached mature years, he does not appear to have learned from experience, save to become more sophisticated in the manner of his sinning. Neither fines, suspended sentences, nor short-term effective imprisonment have succeeded in deterring him from breaking the law again. The appeal is dismissed. Her written judgments reflect her intrinsic grasp of legal principle. For instance, her understanding of what constitutes true remorse as distinct from regret at having been brought to book, as she indicated in the State versus Phillip case. Late offer of compensation is, as she said, a hollow gesture, where the appellate had been given various versions of what had motivated him, and I quote, falling into error as he did. In her judgment, she recognized that comparing the sentence imposed in one case with the sentence under review had its limitations, as personalities and circumstances were never the same. However, comparison between similar cases, and I quote, reveals at least that this sentence is not out of line. Accordingly, the court found itself powerless to interfere as the decision of the court a quo had been properly and judicially determined. Similarly, in the case of S versus Sinden, Van den Heever JA, writing for the unanimous court, clarified the sentencing principles regarding correctional supervision. In her hand, the appellate division held that, and I quote, the appellant showed no sign of true remorse, which of necessity involves a true appreciation of one's moral guilt. She has little, if any, of that, but sought instead to justify her taking ways. She persistently and deliberately betrayed the trust placed in her and did so from greed, not need. A sentence does more than deal with a particular offender in respect of the sentence of which he has been convicted. It constitutes a message to the society in which the offence occurred. In my view, there are no grounds upon which the court could fault the magistrate for his view that a sentence of correctional supervision would in the circumstances set out the highly undesirable message that crime may well pay after all. That is in the Sinden case. We often rely on her enunciation of legal principles such as these in dealing with commercial crime matters. But we'll treasure the little idiosyncrasies that she let creep into judgments. And I quote, the magic of first love is our ignorance that it can ever end. These are the words of Benjamin Disraeli, which made their way into the Rovex Limited versus the Prima Toys case. Reading her biography, Leo van den Heever did not initially commit to the study of law, choosing instead to major in Latin and English, and upon graduating to teach. According to her, the stature of her father, Toon van den Heever, poet and judge of appeal, already fully occupied that space. However, helping out as a judge's registrar altered her course, and I dare say she espoused the law. After all, as Leo herself quoted of George Bernard Shaw in the Rovex Limited versus Primo Toys case, first love is only a little foolishness and a of curiosity. On behalf of the National Prosecuting Authority and the staff of the Directorate of Public Prosecutions, we recognize and celebrate with Judge van den Heever's family her life, which was lived to the fullest, her monumental contribution to South Africa, not only in law, but in shaping the very life. May the great lioness rest in peace.
Thank you, Ms. Handisudaki. Mr. Minister.
Honorable Judge President, Honorable Justices, members of the legal profession, family and friends of the late Judge Conradie, distinguished guests, ladies and gentlemen, it is a privilege and a solemn honor to pay tribute to the late Judge Johannes Hendrik Conradie, affectionately known as Johan, and I do this on behalf of the National Prosecuting Authority. Judge President, may I pause, and I must remark that it cannot go without mentioning that on the 15th of June, just last Monday, it would have been Judge Conradie's birthday, as he was born June 15, 1938, in Johannesburg. In fact, I note further that the month of June must have been a significant month for him, for we must recognize his elevation to the SUA that took place on the 1st of June, 2002. Before his appointment to the bench, Judge Conradie practiced at the Johannesburg Bar for approximately 23 years. In 1992, he took silk and became senior counsel, a recognition of his standing, skill, and integrity as an advocate. His career at the bar laid the foundation for what would become a long and distinguished period of judicial service. In 1987, he was appointed permanently as a judge of the Cape Division of the Supreme Court, which later now became Cape High Court. In 2002, he was elevated to the Supreme Court of Appeal, where he served until his retirement in 2007. His judicial career therefore spanned a particular significant period in South Africa's legal history. He served through the transition from the pre-constitutional era into the democratic constitutional dispensation. That was a time which required judges not only to apply the law with technical competence, but also to contribute to the credibility and legitimacy of the courts in a changing society. Judge Conradie did so with dignity, discipline, and independence. As prosecutors, we recognize and honor the central role of judges who approach criminal justice with fairness, restraint, and fidelity to legal principle. Judge Conradie's judgment reflected careful reasoning and respect for the limits of judicial power. In the earlier mentioned matter of Abrahams and others, which is dated the 12th of March 2002, and I note with pleasure that our erstwhile Director of Public Prosecutions, Advocate de Kock, was instructed by the Director of Public Prosecution for the respondent in this matter. I note with pleasure also that at that time, Judge Conradie sat with Judge Binswood, who was at that time an acting judge. As I proceed, in Abrahams and others, where he sat with acting Judge Binswood, the court considered whether petrol bombs fell within the statutory meaning of armaments under the Arms and Ammunition Act. The court held that they did not, emphasizing the need for proper statutory interpretation and the importance of not extending penal provisions beyond their lawful meaning. And I note with pleasure that at the time, the term armaments that the state had preferred to use in charging these accused in the act was not defined. So Judge Binswood at the time, as he was acting together with Judge Conradie, resorted to various forms of definition that they found in the dictionary. And at the end, the court considered whether petrol bombs fell within the statutory meaning of armaments under the Arms and Ammunition Act. The court held that they did not, emphasizing the need of proper statutory interpretation and the importance of not extending penal provision beyond their meaning. That decision illustrates an important quality of judicial office, the courage to apply the law as it is, properly interpreted, even in difficult or emotionally charged circumstances. It reminds us that the rule of law is protected not by outcomes alone, but by the integrity and the reasoning that leads to those outcomes. Another example appears from S versus Adams, where Judge Conradie dealt with a legality of criminal proceedings involving an accused person whose mental fitness had been called into question. The conviction was set aside because the court could not properly proceed, may not have been able to understand the proceedings or be held criminally responsible. It is of particular interest, as this is one of my portfolios as one of the deputies serving in the division dealing with mental referrals, that this matter dealt with an accused who the presiding officer did not give sufficient time as was an issue. the bedding that we are experiencing, to that extent that, in fact, we had an opportunity to sit and consider the lengthy time that the bedding takes before an accused can be assessed whether the person is fit to stand trial and or was able to appreciate the conduct at the time of the commission of the crime. The parallels are amazing when one takes a pause to read how similar the circumstances back then, as we may perhaps at times consider it unique, they are actually not. For those of us in the prosecuting authority, that principle is fundamental. Criminal justice is not only about conviction, it is about lawful process, fairness, and the protection of the dignity of every person who comes before the courts. Judge Conradie's approach in such matters reflected a deep appreciation of those values. But today, we do not remember only the judge, the advocate, the silk, or the jurist. We remember a life of service. We remember a professional life devoted to the law, to the courts, and to the administration of justice. We remember a man whose contribution is found not merely in appointments and reported judgment, but in the example that he set. Disciplined reasoning, independence of mind, professional integrity, and quiet authority. Family, we extend our public tribute can fully capture the private loss you have suffered. The law may remember Judge Conradie for his judgments and his service. You will remember him in a more personal and intimate ways as family, as loved one, and as someone whose presence cannot be replaced. To his colleagues and to the judiciary, we share in your loss. The passing of a judge of his standing is the passing of an important part of our legal history. On behalf of the National Prosecuting Authority, I pay tribute to Judge Johannes Hendrik Conradie, advocate, senior counsel, judge of the Cape Division, judge of the Supreme Court of Appeal, and servant of justice. May his contribution to the South African law continue to inspire those of us who bear responsibility within the justice system. May his soul rest in peace. I thank you.
Thank you, Mr. Pulesa. The next speaker is Mr. R. Klutze from the Legal Aid South Africa.
Esteemed guests, fellow honorable justices, presiding officers, and members of the judiciary, to all other key role players in the prosecution and those on the defense counsel benches, as well as the bereaved members of the families, I convey the following message on behalf of our Provincial Executive of Legal Aid South Africa. I greet you warmly this day where we have gathered to honor two pillars of our profession. I am grateful for the opportunity granted to me. Today, the task given is to shed light on the impact and memory of two legal minds, on who has left us too soon and who has run a full race. Many in this room may have interacted with these two guardians of our profession, and many would have shared friendly chatter with the two late honorable justices. Excuse me. And many in this room would have also been in serious legal debates in the courtroom or in legal consultations. The late Justice Leonora van den Heever was a trailblazer in many ways in the legal profession and judiciary at large. Being the first female advocate and the first ever female appointee into the judiciary, the ground broken by pioneers such as the late Honorable Judge cannot be overlooked and undermined. We can safely say that the appointment of the first female Constitutional Court Chief Justice can be celebrated on equal footing as the appointment of Judge van den Heever nearly 55 years ago. Despite these two appointments being made at different times, under different political environments, the role that the two female leaders have played thus far will indelibly mark for future generations to look at and seek to acclaim the same heights and prestige. Late Justice van den Heever's role and actions raises the hope and pride for women at large and as an inspiration to minority groups and activists. The work that the late Justice van den Heever did in the field continues to be critical, such as interpretation of the Divorce Act, It's helpful to have experienced legal minds apply themselves to legislation that assists future generations understand both simple and complex subjects in that regard. When considering the impacts and role of the late Honourable Justice Conradie, much must be said about his rise through the ranks of the judiciary. We were all saddened by the manner the Honourable Judge left this world. Many in this room were prior colleagues, friends, and professional acquaintances. Throughout his career as a judge, the bravery of the late Justice presented not shy away from complex matters, and during his tenure at the Supreme Court, the judge's notable judgments are something to review and take note of as they demonstrate rigorous analysis of appellate records. His judgments during this period reflected a commitment to precedent and statutory fidelity, influencing SCA jurisprudence on procedural equity and fiscal enforcement. One can continue to unpack the impact, work, and influence of these honourable judges, who are no longer living members of the point. They are proof that our work, regardless how common, simple, or predictable it may seem, has the opportunity to echo throughout the times, and showing that working as one with fellow like-minded professionals, or even those with opposite sentiments, can make greater impact. Thank you.
Thank you very much, Mr. Pluter. Next speaker is from the Black Lawyers Association, Mrs. Ndana.
Justices, Judge President, members of the bench, colleagues, and the families of the late Justice Conradie and the late Justice van den Heever. I rise on behalf of the Black Lawyers Association Western Cape to honor two trailblazers, without of whom many of us would not be standing here. I am tasked with honoring the late Justice van den Heever, who was born in Windhoek on the 9th July in 1926, a daughter of a judge. The law was, in one sense, her inheritance, but the place that she came to occupy within it was not inherited. It was taken against the grain of an entire profession that had decided long before she arrived that the bench was no place for a woman. She came to law almost by accident, and we are told that her first love was language and literature. It was her father who coaxed her into acting as his registrar, and from that point beginning grew a career that would change our history. In 1969, she was appointed to the Northern Cape Division, and South Africa had for the first time a woman on the bench. We must be honest about what that meant and about what it did not yet mean. There was no precedent for her, no woman ahead of her to follow. What opened was a door that was not given permission for her to open, but it was her refusal to accept that it remained closed. Let us not pretend that once the door was opened, it remained open for all others. And that is why we also stand on the shoulders of other women who stood with her, like the likes of Sisirul and Desiree Finger, who were also the Black first women admitted as legal practitioners. We also stand on the shoulders of women who came after them in rooms that did not want them, but they remained. We do not enter this profession as guests in other women's history. We come carrying our own. We are taught that practitioners look up to the bench, and yes, we do. But we also look up while remembering the women who were locked out of this very room, but chose to enter. That refusal is what binds them together to the late Justice van den Heever. Hers was a stubborn spirit, a refusal to sit down, a refusal to be told that a clarity of mind and soundness of judgment belong to one sex. It is that same stubbornness and spirit in our foremothers that turned and closed that turned a closed profession into one where women now can argue and judge. She rose again in 1991 by becoming the first woman to serve permanently in the Appellate Division, now the Supreme Court of Appeal. She gave judgments of clarity and convictions on procedure, and with her famous suite, had no fear of calling out injustices. When she retired in 1996, she put down her pen to write judgments and took up again her pen to become an author, which goes to show a mind like hers could never sit idle. Today, we have a woman justice sitting as a Chief Justice of the Republic, and there are women on the bench in this very same room who also lead. We honor them, and without apology, we do say that the work is not finished. To her family, thank you for sharing her with us. She has helped the profession crack open doors that were not easy to open. She shouldered the women in this country, and we do call her Imbokodo. May her soul rest in peace, and may her stubborn spirit live on in every woman who rises after her. Insimbi engagobi, translated as the iron that does not bend. Long live the spirit of Imbokodo. And I must say as a parting note that it is heartwarming as a young woman with other passions who found herself in this profession by chance, that one does not have to have one passion, but can also pursue other passions.
Thank you, Ms. Mdana. From Nadell, Mr. Donan SC. From Nadell, Mr. Donan SC. Good morning.
Judges. On behalf of the National Association of Democratic Lawyers, I extend our deepest sympathy to the families of the late Justices Leonora Heever and Johan Conradie. We honor their lives, memories, and example. I am old enough to have had the privilege of appearing before both of them on a few occasions. They proved to be very serious, very capable lawyers. They did not suffer fools gladly, but were both endowed with a spirit of empathy that transcended legality for legality's sake. Because of the nature of my practice between 1984 and 1994, they were never part of the allocated pool of judges before whom I appeared during this period. My experience before them in court was therefore limited, but I am qualified to say that I thoroughly endorse the praises already heaped upon them by others. On the two occasions I found myself before her, Justice van den Heever was patient but practical. She kept me to the nub of things, and then she gave model judgments, clear, succinct, literate, compelling, and elegant. As a junior advocate, I felt that my clients would always receive justice in her hands. The reported judgments manifest her gift for language, words, and expression unmatched by most judicial officers. To see this gift at work, one needs to go no further than the beginning of her judicial career and the reported review judgment in S versus Peterson, reported in 1969, Volume 4. But her cases have been quoted in depth by others at similar memorials. So I shall skip those and move to the CPT case of State versus King, which was hardly reported except by the press at the time, and eyewitnesses like my next-door neighbor, an 85-year-old nudist. The judge's gift for language and her approach, practical approach, to the role of law in society were paramount in this case. Tens of people were arrested for public indecency at Sandy Bay, a well-known nudist beach which was accessible only by a 1-kilometer trek through thick fynbos. A large contingent of police under the command of a colonel had been deployed to cut off every avenue of escape and arrest everyone on the beach. Inevitably, the trial court was packed with lawyers. In dealing with the charge, Justice van den Heever noted that the human body is not indecent, and that indecency depends on the specific circumstances, the nature of the beach, and the potential audience. Merely being present is not synonymous with the offence of exhibiting. That requires an action showing oneself publicly for the purpose of amusement or instruction. The judge then questioned the colonel in charge of the operation on crime statistics for rape and violent crime in Cape Town in the immediate past and on the day of the alleged offences. Then she asked him whether he really thought that the state should be mass arresting naked beachgoers while more serious crimes like murder and rape were taking place. He answered no, and the state was embarrassed and constrained to stop the prosecution. Ms. McCurdy and Ms. Madonna have expressed with more qualification than I some of the hardships suffered by Justice van den Heever because of her gender. So I shall confine myself to what she found herself up against when she decided to leave teaching and join the advocate's profession. Advocacy was a profession which, to quote Justice Krichler in a eulogy, was a closed and relatively inbred society, its members keeping tabs on one another and, of course, freely engaging in gossip. It was, and these are my own words, a society whose attitudes were further engendered by the legal icons of the society, employing words that were sometimes cruel and, for present purposes, violated the dignity and humanity of every woman for being the person God had made her. I refer, of course, to the judgment of Innes, acting Chief Justice, as he was then in Incorporated Law Society against Wookie, 1912 AD, to the effect that, as the common law at the date of the passing of the Charter of Justice did not permit the enrollment of a woman as an attorney, it was impossible to infer from the use of the word persons an intention in the Charter to effect so important an alteration as to include women in the word persons. This judgment was rejected by the President of the Supreme Court of Appeal in a Black Lawyers Association memorial last year. 3 years before the birth of Justice van den Heever, legislation allowed women to practice as an attorney. But by the time I joined the bar in 1983, this legislation had no more imbued advocates and judges with women than the 1993 and 1996 constitutions imbued advocates with Ubuntu a decade later. And so, as many people in this court today have experienced, because of their gender or race or both, Advocate van den Heever did not, in her own words, share in the easy money briefs. She took silk in reaction to a remark by a senior colleague that because she was a married woman, her practice was actually a hobby. And when she was deservedly appointed to the bench, the Minister of Justice remarked that it was an experiment. What nagging doubts must have persisted in her mind about hidden prejudice still lurking in the minds of her colleagues as she held court as South Africa's only female judge for 25 years. I can only wonder. I wondered too why a person of such strength of character, resilience, and brilliance should have given up the ghost 1 year short of her 100th birthday. I would like to think it was because she knew that by the time we gathered here today, this court and our apex court would have been finally entrusted to safe hands, and that she could, at last, rest in peace. May she do so. Major General Kolisi Patani had no doubt whatsoever that Justice Johan Conradie saw him as a person and treated him with respect. Nor would anyone who attended his trial in this very court on charges of terrorism before the learned judge have had any doubt. That case is tucked away in the 1988 3 law reports, but it is more famously contained in the manual of the International Committee of the Red Cross and utilized wherever the international law of armed conflict is taught, particularly in asymmetrical warfare, that is armed conflict between a conventional national defense force and a people's militia, like the ANC's armed wing Umkhonto we Sizwe once were. The Patani example was followed by Marwan Barghouti, often referred to as the Palestinian Mandela, in his trial by an Israeli court for alleged involvement in 5 deadly attacks during the Second Intifada. Patani claimed recognition as a prisoner of war as contemplated by the terms of Protocol 1 to the Geneva Conventions. The situations contemplated there included armed conflicts in which peoples are fighting against colonial domination and alien occupation, meaning the Palestinian people, and against racist regimes, meaning the black people of South Africa, in the exercise of their right of self-determination as enshrined in the Charter of the United Nations. This claim could never succeed because no judge in the South African court could ever have labelled himself and the government that appointed him as an illegitimate racist regime against whom the people were entitled, as a matter of international law, to confront in armed conflict. However, war is an extension of politics by other means. The state, as was pointed out by Judge Conradie at the outset, when the prosecutor laughed at the prisoner of war claim, that the state had admitted in its further particulars that the South African Defence Force was at war with the ANC. The state had allowed Patani some political space that the liberation movement would never have enjoyed were it not for his trial. The purpose of the POW claim was political. It was what they call today lawfare, a propaganda exercise in which the accused diverts the label of terrorist from himself to his accuser in order to build up international political support for his people's struggle. In this, Patani had a measure of success through the international and domestic press and through the many dignitaries and diplomats who flocked to the trial once he had raised his claim. In his erudite and thoroughly researched judgment, Justice Conradie noted that Oliver Tambo, the president of the ANC, had handed the president of the Red Cross a declaration to the effect that the ANC intended to be guided by the general principles of international humanitarian law applicable in armed conflicts, and that wherever practically possible, it would endeavor to respect the rules of the Geneva Conventions and the additional protocol. But the Geneva Conventions are akin to contracts, and the protocols were never signed by South Africa. Patani's case, therefore, had to rest on demonstrating that the protection of the protocol were part of customary international law and therefore the law of South Africa. This required him to prove that the state practice of the superpowers was to follow the obligations contained in the protocol because they regarded themselves as being bound to do so in law. Justice Conradie made it very clear why they could never do so. Nevertheless, the recognition of the ANC's right to resort to armed conflict for the purpose of achieving freedom from apartheid, and also the status of combatants for their cadres, remained one of their political priorities. In demonstrating state practice at the time, recognizing these rights, his legal team were assisted by the Australian government under Bob Hawke. Thabo Mbeki and Lusaka gave our legal team permission to raise the prisoner of war claim, provided Patani was prepared to take the risk of provoking his own execution in a division where more people had been sentenced to death in the previous 2 years than had been murdered by the state at Sharpeville. When he was asked to plead, he stated in a calm and dignified manner, and with the utmost respect to Justice Conradie, that he did not recognize the jurisdiction of the court, and he claimed that he was a prisoner of war. On the international law, we were assisted by Professor Kader Asmal at Trinity College, Dublin, John Dugard, Richard Falk, and the Max Planck Institute in Germany. In a comprehensive and cogent judgment, Justice Conradie explained exactly why the preliminary point did not and could never succeed. But this is the point of my eulogy. The trial continued, but by then the discipline and respect that Patani displayed throughout the presentation of his case had struck a chord with the judge, who reciprocated with equal respect. He accepted Patani's evidence above that of a security police expert that the car bomb Patani had placed in the parking lot of a Goodwood shopping centre, 10 metres from a toy shop window, during the school holidays, was never meant to go off, but was intended to induce the security forces to redeploy their forces from the township to the white areas, because MK were capable of taking the war into those areas. No one has ever spoken from that day to this about what Patani did. But crucially, no question of a death sentence ever arose. The judge answered my argument that Patani's character was such that he might well one day make a contribution to this country with the words, and I quote, "Yes, my own feelings are that he is likely to." In that, Justice Conradie was correct. Major General Patani lived to become the Inspector General of the South African National Defence Force and was afforded a state funeral. Before his passing from diabetes, Polisi proudly told me that Justice Conradie had been in touch. So it is with deep sorrow that I bid farewell to this great and visionary judge. Thank you.
Thank you. Thank you, Mr. Dillon. The next speaker is from Advocates for Transformation, Mr. Norman Arendse, SC.
Thank you, Judge President, Deputy Judge President, former President of the SCA, Howie, the judges of the SCA and sitting judges and colleagues. I start off by extending heartfelt condolences to the Van der Heever and Conradie families who are here this morning, and we pay tribute to them for their service to the profession, to the judiciary, to our country, and for having played meaningful roles so well articulated up to now by speakers, including Justices Howie and Brandt. We honor Justice Van der Heever for her pioneering and groundbreaking role as a woman in both the legal profession and the judiciary. President Howie had spoken about the many challenges she faced and conquered during her years at the bar and in the judiciary. Many of the challenges faced by women are still in play today, although much has changed and improved, as evidenced by the diverse bench we have in court today. And Judge President, you yourself, your appointment and your deputy in recent years, and we applaud that, but much of that would not be possible, and certainly not if female judges like Leonora van der Heever hadn't set the trend. Her humanity and invaluable contribution to the profession, respect for the law, and her ability to deliver clear and straightforward judgments defined her as a lawyer and as a judge. We recently, when we argued on behalf of the General Counsel of the Bar, the challenge by the 4 big legal firms to the Legal Practice Code in Pretoria a few weeks ago, we had the privilege of mentioning her in the context also that she followed our first admitted female advocate, Irene Antoinette Giffen, who was the first female advocate admitted to the Transvaal Bar in 1923. Some of you in court today may recall that she was the mother of Felicia Kentridge, who was married to Sydney Kentridge. In 2023, we celebrated and marked 100 years of the promulgation of the Women Legal Practitioners Act 7 of 1923, which allowed women to be admitted as legal practitioners. Women have made their mark in our history since those 2 iconic judges that I've mentioned. The first black female justice, Yvonne Mogoro, to the Constitutional Court, our current Chief Justice Meyer, a number of judges, President, including yourself, Judge President, and appellate and Constitutional Court judges. We thank Leonora van der Heever for setting the irreversible trend going forward. I move to Justice Johan Conradie, whom I met for the first time in 1988 when I started here at the Cape Bar. Some of you may know that he was a very keen, no, not keen, he was a serious cyclist. And, you know, there weren't many things to discuss of mutual interest when you meet for the first time, especially in our country at the time, although the winds of change were already blowing through the corridors of the court and the country. But one of the topics that we discussed was cycling. And yes, Lee, he introduced me to the August cycle for the first time and said, you've got to do this. He was very serious. He did a number of sub-4 hour August cycles, which I never managed to achieve, but tried.
So it was an important and yet welcoming experience that I had with him. And early on here at in the Cape High Court, Johan Conradie sat in a number of labour law matters. And I recall looking at former President Howie sitting over there. One of my very first matters was a judicial review where I acted for a trade unionist, defined, designated as coloured, who was then organising black African workers to become members of a union that was defined in terms of our Labour Relations Act along racial lines, and the union summarily dismissed him. We came to court and brought a victimization case and said that his dismissal was unlawful. Of course, we didn't have the constitution at the time, and certainly we were fortunate enough to have Judges Conradie and Howie on the bench. The case started at 10 o'clock. I think I left this court at 10:30. It took a while for me to realize what happened, but apparently I won the case. There was another matter where Judge Conradie sat with late Henny Nell as a judge, also involving the right to strike, where then House of Representatives, some of you may remember the apartheid days, that was for coloureds only, and workers went on strike. We came to court to protect them from dismissal. That application was also successful. I had since then also had the dubious distinction of asking for his recusal in a matter that turned out to be the first Labour Appeal Court matter that was heard in the Constitutional Court in 2000, the matter of Irvin and Johnson versus the National Union of Metal Workers. And the basis for the recusal application was because of comments that him and Justice Nicholson would have made in a previous matter about the conduct of the NUMSA members. That application was dismissed in a majority judgment. So I do, and of course, I had a lot of respect for Justice Conradie, especially in the field of labour law, where I had initially practiced. Of course, his judgment spans the law of DELIC, administrative and procurement law, insurance law, of course, labour law, constitutional law, and in insolvency. He is best known for his sophisticated analysis of the interface between labour relations and PAJA. Another important case also in labour law that is reported, the Naptosa versus Minister of Education, that also raised questions of the intersection between labour law and administrative law. And it's a matter that's been cited many times in the law reports. When you join, or when I joined the bar, as a black practitioner. It is so important, certainly at that time, to meet and engage with and appear before judges who are basically just quite nice to you. And he was one of those judges. So we want to thank him for the years that he sat here in this court, and it was also a privilege to appear before him in matters when he sat in the Supreme Court of Appeal. We thank his family for his service to us in the legal profession, black practitioners, and also for his service here in this court. Thank you very much.
Thank you, Mr. Arendse. The next speaker is Ms. Alexandra Gillis from the National Bar Council of South Africa. And I would request the last two speakers, in the interest of time, to please be brief. Thank you.
Thank you. It is a privilege to address this memorial service on behalf of the National Bar Council of South Africa, Eastern Cape Chapter, as we honor the lives and legacies of Judge Heever and Judge Conradie.
And what that legacy continues to mean for generations of women in the legal profession. Before doing so, however, it is important to remember that while we speak today of pioneers, jurists, and distinguished servants of the law, the loss is felt most deeply by their families and loved ones here today. Judge van der Heever lived a remarkable life of 99 years and leaves behind an extraordinary legacy. The legal profession honors her today for concise judgments and her contribution to our law. The members of the NBCSA, reflecting on Judge van der Heever's contribution, are reminded that no pioneer stands alone. Before Judge van der Heever became South Africa's first woman judge, there were other women, such as Madeleine Woekie and Sonia Schlessen, who challenged exclusion from the legal profession itself. The sisterhood and justice who questioned assumptions about who could study law, who could practice law, and who could lead within the profession. There were also women such as Desiree Finker, whose achievements stand as milestones for transformation of the legal profession and demonstrated that barriers of both race and gender could be challenged and overcome. These women helped create pathways where none had previously existed. Judge van der Heever carried that legacy forward. Her appointment as South Africa's first woman judge in 1969 is a historic milestone, yet her legacy rests on far more than being the first. She earned distinction through the quality of her work, the strength of her intellect, her independence of thought, and her commitment to justice. She demonstrated through excellence rather than proclamation that judicial leadership was not defined by patriarchy. Her subsequent appointment as the first woman permanently appointed to the Appellate Division further cemented her place in South African legal history. Even more importantly, it expanded the horizons of what women entering the legal profession could imagine for themselves. Today, women serve with distinction throughout our courts and professional associations. Women occupy leadership positions within the judiciary and continue to strengthen our legal system through their scholarship, integrity, and commitment. And this reflects progress that earlier generations could only have imagined. We are also mindful that the story of transformation within the legal profession did not end with the appointment of the first woman judge. Much progress has been made, yet this journey of change remains unfinished.
while women now occupy positions of leadership throughout our courts and profession, many continue to navigate challenges relating to access, opportunity, advancement, mentorship, and recognition. For many women, and particularly Black women legal professionals, barriers may no longer be expressed through formal exclusion, but it may still be experienced in more subtle ways. The challenge for our generation is to ensure that the doors opened by pioneers such as Judge van Heever remain open, and that those who walk through them are able not only to enter, but to flourish within the profession. In many respects, this is the true measure of Judge van Heever's legacy. The women who currently serve on our bench continue to build upon foundations laid by those who came before them, and that is evident from the female leadership of this esteemed court at the moment. In turn, they create opportunities and possibilities for future generations of female and Black legal practitioners. The most fitting tribute the NBCSA can pay to Judge van Heever is not merely to remember her achievements, but to continue creating opportunities for women in the legal profession and to ensure that future generations are able to build upon the foundations that she helped lay. We honor her memory, and not just the memory, but the enduring legacy she leaves to future generations. And we also extend our sincere condolences to the family of both Judge Leonora and Judge Johannes Hendrik Conradie. Thank you.
Thank you, Ms. Alexander Gillis. The last speaker is Ms. S. Samai from the South African Women Lawyers Association.
Thank you. Judge President, judges in this honorable court, retired judges of this division and other divisions, as well as representatives of the legal organizations, members of the organized profession, distinguished guests, members of the families of the deceased, as well as all protocols observed. Good morning, goeiemorgen, molweni nonke, sawubona nonke. It is both an honor and a solemn privilege for South African women lawyers to participate in this sitting and to pay tribute to two distinguished jurists whose lives were dedicated to the service of justice and the rule of law. As we gather today, the day after South Africa commemorated Youth Day, we remain mindful of the young people of 16 June 1976, whose courage and sacrifice helped shape our nation's journey towards freedom, equality, and constitutional democracy. The rights and freedoms and institutions that we cherish today were built upon the sacrifices of many South Africans, including those young people who stood against injustices. It is perhaps fitting that as we reflect on those who helped shape our country's future, we also remember two judicial officers whose lives were devoted to building and strengthening the legal institutions that serve our democracy. Before turning to their remarkable contributions, allow me to briefly introduce our organization. The South African Women Lawyers is a national organization committed to the advancement and empowerment as well as development of women in the legal profession. We wish to strive to promote substantive equality, and for decades, SAULA has worked to ensure that women not only enter the legal profession, but are afforded opportunities to lead, to excel, and to shape its future. It is therefore particularly fitting that we gather today to honor a woman who has changed the course of legal history in South Africa, and a judge whose wisdom and scholarship enriched our jurisprudence for more than 2 decades. Before turning to the lives we commemorate today, it would be remiss not to acknowledge the significance of our nation's history. Judge Leonora was a pioneer in every sense of the word. She commenced practice as an advocate in 1952 A year later, 1969, she made history when she was appointed to the bench of the Northern Cape Division. Today, women serve with distinction at every level of the legal profession. Women preside in our courts, lead law firms, take silk, teach in our universities, and occupy positions of influence through the justice sector. Yet, it is important to remember that this reality did not emerge by chance. It was built upon the courage and the determination of women who were prepared to enter spaces where women had never before been welcomed. Judge van der Heever was one such woman. Her appointment was not merely a personal achievement. It represented a breakthrough for countless of women who would follow. Every woman who has since been appointed to the bench, every woman who has risen to leadership within the profession, and every woman who today enters a law faculty believing that judicial office is within her reach, stands in some measure on the foundation laid by Judge van der Heever. Her trailblazing journey did not end here. She joins the Cape Provincial Division in 1991, and once again made history by becoming the first woman permanently appointed at the Supreme Court of Appeal. Even after retirement at the age of 70, her commitment to justice remained undiminished, and she continued to serve in the CPD as well as the appellate courts of Lesotho and eSeTuani, demonstrating that service to the law is not merely a profession, but a lifelong vocation. Judge van der Heever lived to the remarkable age of 99, in a life spanning almost a century. She witnessed profound changes in South African society and in the legal profession. Importantly, she was not merely a witness to those changes, she was one of the people who made it possible. So as Saula, we remember her with profound gratitude. We honor her not only for judicial office, but for the doors that she has opened, the barriers that she has broken, and the example she set for the generations of women throughout South Africa and beyond. Her legacy continues to inspire us in our ongoing pursuit of equality, transformation, and excellence within the legal profession. And I would say, let her name be praised, Malibongwe. We also honor now the memory of Judge Conradie, whose service to the court and to South African jurisprudence spanned more than 2 decades, born on 15th of June 1938. He was admitted as an advocate in 1964 and practiced at the Johannesburg Bar in 1982. South Africa benefited from Judge Conradie's judicial service for more than 20 years, and tribute in The Advocate in April 2026. Trevor Mensley, SC, described Judge Conradie as an outstanding judge and reflected on the lasting impression he made on practitioners. He also related that numerous judgments delivered in the various courts contributed to the development of an important and highly specialized area of South African law, in particular tax. So those judgments continue to guide practitioners and remain part of our legal heritage. That is a legacy to which every judge aspires. Their work continues to serve the law long after they have left the bench. So we honor Judge Conradie's service to this court. His contributions remains part of the enduring jurisprudential legacy of our courts. Both judges dedicated their professional lives to the law. Both served the courts of this country with distinction. Both strengthened the institutions they served, and both leave behind legacies that continue to influence our profession and our jurisprudence. As legal professionals, we honor their memory not only by remembering their achievements, but by striving to uphold the values they embodied, and by continuing the work of building a legal profession that is transformed, ethical, committed to justice for all. On behalf of SAULA, South African Women Lawyers, we extend our deepest condolences to the families, the friends, the colleagues, and the loved ones of Judge Leonora van der Heever and Judge Johannes Hendrik Conradie. We thank them for sharing these remarkable individuals with the legal profession. Judge van der Heever's legacy reminds us that courage can transform institutions and create opportunities for generations to come. Judge Conradie's legacy reminds us that dedicated judicial service and enduring jurisprudential contributions continue to shape the law long after a judge has left the bench. May their memories continue to inspire us. May they rest in peace. Hamba Kahle. Thank you.
Thank you, Mr. Mai. As we close the ceremony, I would like to thank our two justices for delivering the eulogy, as well as all the speakers for the words that you've shared with us as the bench, and most importantly, with the families. I'm sure that the words and the memories that you've shared have lightened the hearts of the loved ones. I want to thank our retired colleagues for coming all the way and for making time every time we call on you. We really appreciate that. And thank you to my colleagues for your patience and also for agreeing to adjourn the courts until 11:30, as is our tradition. And I really want to thank the families for honoring us and for allowing us to share the colleagues and have this memory and ceremony today. I know that you came all the way from different parts of the country and even abroad just for this special day. So we really appreciate that. I know it took a long time for this ceremony to take place because there was a lot of coordination between the court and the family. We really appreciate that. We appreciate Judge Sher and also the officials and staff members of our court and the provincial office of the OCJ for organizing this event, and everyone who was really involved in making sure that this event is a success. Lastly, Mrs. Conradie, former Chief Justice Zondo said I must convey his condolences. He would have loved to be here today. He worked very well with Judge Conradie in the Labour Appeal Court, but due to circumstances beyond his control, he couldn't be here today. He learned with sadness his passing. To both families, we hope that you will continue to be strengthened, and we hope that the words that were spoken by many colleagues as well as the legal profession have really played a role in strengthening you today. May the souls of the departed colleagues remain and continue to rest in peace. Thank you very much. The court will adjourn and we will invite the family as well as the speakers to the refreshments. Thank you very much. Court adjourns.